Good morning. Welcome to the Michigan Supreme Court, September 18th, 2024 public hearing. We have two items on the agenda with speakers. The first item is ADM file 2021-05, proposed amendment of MCR 6.302. And we have Jacqueline McCann from the State Appellate Defender Office.
Good morning, Your Honors. Jacqueline McCann on behalf of SATO. We did write to Your Honors with a pretty lengthy letter, and I don't want to repeat all of that. So I wanted to talk a little bit about the difference between the prior proposal and this proposal. So there was some pushback on the prior proposal because it stated that if the preliminary evaluation wasn't accurate, that the person was entitled to withdraw their plea. That proposal included a change to 6.310. So this one is different, and it implies that just because the initial estimate is wrong doesn't mean you're going to get to withdraw your plea. And we think that is at least inconsistent with the existing case law to some extent. And we cited in the letter to Cobbs, but I also wanted to point the court to People versus Boatman 273, Mich. App 405, 2006. This court overruled part of Boatman that had to do with habitual offender maximums and having to tell the defendant that they were subject to the habitual offender. But the part of Boatman that still stands, and the reason he actually won, was when they were telling him what the guidelines range was going to be or what they thought it was, they were off. They gave him numbers that were not remotely the numbers that he was facing because of the habitual. And the Court of Appeals said it was nonsensical to assume that a defendant whose own attorney didn't know what the guidelines range was entering a knowing, voluntary, and intelligent plea. And so we would like the court to take out that ambiguity, or instead of this proposal, what we would really like to see the court do is even the playing field. The reason that some of these evaluations are so far off is because they don't know the defendant's prior record at the time they're making the plea offer from the prosecutor or the evaluation from the judge. They're on an even playing field as far as the OVs, because they all have the discovery and they all have any prelim examination transcript. But where they're not on an even playing field is access to the prior record. And if you give the defense attorney his client's prior record, it's really the defense attorney's job to calculate the guidelines and to advise the client what they are, and go into negotiations from that standpoint. And we think that is the better route to go, or at least in conjunction with the court's proposal. But we worry about the tension between 6.302 under the proposal and the rule for plea withdrawal.
Thank you very much. Any questions, comments? Thank you.
Thank you.
Item number 2 is the ADM file number 2022-10. And we have two speakers. This is a proposed alternative amendments of MCR 8.126 to clarify and streamline the process for Pro Hoc Vici admission to practice in Michigan courts. First up, for the Attorney Grievance Commission, we have Kimberly Uhuru.
Good morning, Justices and Chief Justice Clement. The Commission's comment this morning is regarding Section E, regarding revocation of Pro Hoc Vici admission. And this section is found in both proposed amendments. The Commission is requesting added language that would require a tribunal to report revocation of temporary admission to the Attorney Grievance Commission. And this is because in the event that revocation is for an instance of professional misconduct, reporting would enable the commission to open an investigation and take any appropriate disciplinary action. Similarly, reporting should be required to the attorney's home state because that would allow that jurisdiction to take reciprocal action, which foreign jurisdictions typically do when they're involved in misconduct in another state. I would note that both versions of the rule do provide the AGC with jurisdiction to investigate misconduct by a Pro Hoc Vici attorney. Reporting would facilitate the commission carrying out that duty. And it's also consistent with Michigan Rule of Professional Conduct 8.3, which requires all lawyers to report significant violations of misconduct to the commission. The commission does support these proposed amendments, and we thank the court for the opportunity to comment.
Thank you very much. Any questions or comments? Thank you. Next up, we have Karen Jadkis from Legal Services Association of Michigan.
Good morning. Yes, my name is Karen Jadkis. I am the Director of Litigation at Legal Aid of Western Michigan, and I also speak today on behalf of the Legal Services Association of Michigan. We are speaking in support of these the proposed amendments to this rule. Hiring at legal services can be tough. While we offer an excellent work environment and interesting and important work, we don't offer the highest paid positions in the legal community. And in the last several years, we've had more openings than applicants, and recruitment and retention have become much more difficult. When positions are not filled, we are hindered in our ability to provide legal services to our communities, which are already underserved, as well as comply with our grant requirements. This problem is not unique to Legal Aid of Western Michigan, but is the common experience of all the legal services programs in the state of Michigan. We do have out-of-state applicants apply for our positions. Many of these applicants have excellent experience and are looking to relocate to Michigan as a return to their home state, to be near family, or they've figured out what the rest of us already know, that Michigan's just a great place to live. However, while we have a court rule that allows law graduates to practice for up to a year before licensing, under supervision and with court permission, of course, our out-of-state attorneys do not have such a process, and instead we are forced to rely on the Pro Hoc Vice process. The current process is limited and expensive, costing about $900 for just 5 cases, and that 5 cases is the limit. As some of our legal services attorneys close over 100 cases a year, 5 cases just isn't that many. For an eviction attorney, 5 cases is sort of an average week. This puts us in the tremendous difficult position of wanting to hire these out-of-state attorneys who will bring tremendous value to our programs and clients, but having to use them as at best paralegals for 4 to 6 months, if not longer, the time it will take to process their application for admission to the bar. They can't go to court and they can't act as attorneys, even though they're often incredibly well qualified to do so. Because we want to hire them and use them, we do often use them as a paralegal and sometimes do an occasional Pro Hoc Vice admission. But again, it's very limited, and we're kind of in a difficult position here. For example, we had an attorney start in fall of 2020 in our St. Joseph office in Berrien County, which is often one of our most difficult offices to hire for. She had more than 5 years of experience working in Illinois, most of that in family law, a subject area we have a very high demand for. She was a great candidate. We wanted to hire her. We didn't want to lose her to somewhere else. And so we hired her, but we had to use her again as a paralegal during that time. So she was writing pleadings and doing client communication under the supervision of a managing attorney, but we couldn't use her to her full skill set. So we were still really limited, even though we were paying her salary. Eventually, we did pay for a couple Pro Hoc Vice admissions in the spring of 2021, although she was worth it because she's been one of our best attorneys. She now manages that office. But I do wish we had been able to have her do more, especially during that awful time of the pandemic, than we could. Problem still continues. Just Monday, a couple days ago, we onboarded a woman who's coming to us from Massachusetts. She's licensed in Massachusetts, has enough experience to waive in here in Michigan. We are waiting for her application to be processed. Again, she has an excellent background of legal services programs in Massachusetts, representing survivors of human trafficking, doing other legal services work. But again, we're limited in how we can use her for the next several months. So we're, again, kind of forced to use her as a paralegal, maybe do a couple Pro Hoc Vice admissions. But it means that we will likely have to turn down cases where we would otherwise be able to offer full representation until her licensing is completed. The proposed changes.
Ms. Jadkis, I'm sorry, we're beyond your time. Thank you very, very much. Are there any questions or comments from the bench? Okay.
If it's okay, Chief, I'm just fascinated by what she's saying. I I guess my quick question would be is, you were gonna make one last point. What was that?
Really, my last point was just that we support the proposed changes to both cap the fee to only one Pro Hoc Vice fee, and then remove the limits on Pro Hoc Vice cases for those who are employed by legal services.
Great.
Great, thanks.
Thank you very much.
Thank
And we
you.
have no more speakers for the public hearing today, and we are adjourned. Thank you.